Well, thanks for sticking around as I drag that song out every week, waiting for David to show up. All right, so this is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. There's three hosts. My name's Todd Ryan. There's Jeff Neuman and David Michaels. We always seem to wait around for David to come rolling in. He's probably here. I just can't see him yet. Hey, Jeff, how's everything going with you today?
Hey, everything's good. I don't see David listed, but hopefully he's okay and will join us. But things going well here, and looking forward to the show.
Yeah, we got some cool cases, but some news also that I was just reading, Jeff, that I didn't even add to the outline, but we'll touch on it. Um, yeah, and David seemed like a good student if he was in school. Doesn't seem like the kind that would come in, his hair messed up like 2 minutes late, and the professor's like, "Hey, what? the fuck? You come rolling in? Do you have all your shit anyway?" Um, I'm gonna say it to him when he gets here too. It's unbelievable to me. Like I always say, it's like a. I feel like it's like we're Channel 5 News here in LA. Well, we're already a pretty shabby group. Oh, there he is. We're already a pretty shabby group. We can't, start the news 2 minutes late. Hey, hey, David, I'm inviting you up right now. Yeah, a lot of shit's happened. Stuff I meant. A lot of stuff's happened. You weren't here. Well, I guess we'll redo it. I don't know. Hey, one, two, three. There he is. David Michaels, everybody. How are you doing today, David? What's up?
All right, pretty busy. A lot of people want a piece of me today, so it's kind of like hectic.
Yeah. Good. It's good. It is good to have a calendar full of bullshit. And what I mean by that is me. I know my week too been busy scheduling, scheduling calls and then realizing, okay, just because you have a call scheduled, you got to be ready for it. Um, and I try to prepare. Anyway, tomorrow I wanted to let people know I'm doing an interview. Chad and I, he's a business partner of mine, Chad Folkening. We're doing an interview with Fred Sue at D3. Fred is the CEO and co-founder of D3. He's got a DOMA protocol, which is really some blockchain that they've developed to put domains on the blockchain. So not just fractionalizing names, it has to be put on a blockchain, and they developed this DOMA protocol. We're going to talk about that tomorrow, but we're going to talk about domain investing. By the way, I did, if you go to d3.com, they did pick up. They used to be on d3.inc for a year or so, and then they picked up recently d3.com. I think Braden helped him square that away. But anyway, so go to d3.com, click on blog, and you'll see I did an interview with Fred as a warm up to our live interview tomorrow. It was a written interview, and just talking about domain investing a little bit. And yeah, matter of fact, I'm going to, so tomorrow, 10 a.m. Pacific, 1 p.m. Eastern, right here on X. You can go to my timeline and see the link. I don't have it on our DNL show outline. By the way, our domain name law show outline, I update it every week. Boy, spending time doing it. The other guys, Jeff and David, they basically just enjoy the boat ride. It's like me. Here, let me clean everything up and get at least a couple sandwiches ready. I'll drive the. Okay, so it's dnlshow.com/outline. You can see what we're going to cover today and what cases. I put links up there so you can really dive into the cases just like we do. But I wanted to bring up a couple stories that I didn't put on the outline, and that is, yeah, so I noticed one. It was, let's see here. Yeah, stream.ad was, I just saw that Domain Gang wrote an article about it, but bottom line was stream.ad was a domain name that was registered, I guess, in 2018. And I guess AD is Andorra, must be, because the company that was on stream.ad held an Andorran trademark for the name Stream. They registered the name in 2018. They let it drop, and it was registered in October 2024 by a company, One Star Ventures LLC. And what's interesting to me about this case is the when you went to the landing page after this person picked it up, this company picked up the drop name, it had a $9,500 listing. It was a CETO listing. Well, I have I think three .ad domain names: sportsbook.ad, vehicles.ad and want.ad, like one ad. Anyway, I bring it up because if you're interested, reach out to me. But they were saying that this extension, this country code, there were names that were, I guess, frozen or restricted or taken back by the registry because you're not supposed to make .ads for sale. And I thought it was interesting that this one had a for sale lander. It went through the UDRP process, and the domain ended up staying with the domain owner. So, I'm glad to see that. And I'm glad to see that the registry, apparently, they're loosening up. They're knowing people outside of Andorra are buying these .ad names. And maybe they're loosening up on the restriction of, not being able to sell it. But Jeff, and then Dave, if you know. So, Jeff, with these CCTLDs, a country can say you can't make them for sale. That's a legitimate rule that they can enforce, I guess, if they wanted. Does that make sense to you? Have you heard about that before?
Yeah, I mean, it's a CCTLD can, make whatever rules it wants. There's no ICANN oversight, and um, yeah, there's a number of CCTLDs that have anti-speculation clauses, and in fact, some GTLDs used to have. I know when .biz was started, it basically said you had to have a legitimate business use for the domain name, and at that time in 2001, the purchase of a domain for the sole sorry, if you purchased a domain name with the sole intent on reselling it, that was not considered within the definition of being a business. Um, Now that was abolished in 2000, I don't know, somewhere around 2013. But yeah, I mean, you can have those rules. CCTLDs don't have any oversight, so you can kind of plead with them to enforce it if you wanted them to, or they can just ignore it. Nothing really that forces them to enforce their own rules.
Yeah. And I guess GTLDs can have rules too, although ICANN oversees them. But you're right. So I've heard of CCTLDs having rules such as you can't have a gaming site here or pornographic site or really, whatever the country decides that they don't want. But then we see as domain investors, we jump on as soon as they allow us to register, because many times the country will say you must be in our country and show proof. As soon as they let us domain investors register domains, we just do it, and then we hear about the rules later, like, oh yeah, shit, I can't have a gaming site. I'm that was my intention for this, and so on. And we buy gaming names with a certain extension that run foul of the rules, or is it afoul of the rules? And we don't, we just see if they're enforced. Hey, David, do you own any .ad names or any sort of unique CCTLDs other than .ca?
I've got some .cc domains that never sell. So, and I think I used to have some CX names, but I got rid of those. I think I have 4.eus and 1.de. I'm not really investing in those.
Yeah, I did see. It looked like maybe it was somebody, maybe Mr. Premium, somebody, some broker. Maybe it was Grit. I have no idea. I can't recall, but they were selling de.de. I thought, good, over in Germany, somebody must love it. Makes sense. Um, Another, like I mentioned, the outline for you folks who want to check out our outline, go to dnlshow.com. You can just click on outline, or you can go to dnlshow.com/outline. And there was, other than that stream article, there was a couple things that happened in the last. One was who is display. This was Elliot over at Domain Investing put an article up about the who is display at GoDaddy can pose legal risks. And basically, I think I got an email from GoDaddy recently saying your company name is no longer going to be part of the who is. And I use mine, Elliot's top notch domains. Mine is American Business Capital. Well, apparently GoDaddy, you have to flip a switch. You have to basically opt in to have your business show. But ever since that they, have this, it's not even the paid for privacy, it's the the included privacy. I can never tell. I go to my who is. I can't tell that I own most of the names. I know any interested buyer. I don't know. I'd never get any who is inquiries the last 5 years. It's just been terrible. But so Elliot was saying that it shows him as the personal owner rather than his company owning it. And of course, you can fix it by opting in, but you have to do it individually or something. But he just said it could lead to some legal issues. Maybe I need to read his article completely. Perhaps more importantly, if there was ever any type of legal action, a cyber squad lawsuit, it looks like I personally own these names. Yeah, so it doesn't. You're not insulated by your company, your corporation, or LLC, basically. So he's saying maybe somebody could file. If somebody files, Jeff, if somebody files against you personally because it shows on the who is that you own it, but actually you have it really under your company ownership, what do you do in an instance like that?
Well, I mean, you're talking in a UDRP or a lawsuit because there's two different things.
Well,
But
both.
okay, so in a UDRP, um, there is a way um, to get the name of the registrant amended if you can show that it was registered on behalf of an entity. Um, but the case will still be brought against you because you are listed as the owner. Um, but and similar in court too. I mean, it's going to be named against you, but if you can show that there's records of it actually being owned by the company, then you can have that. Usually in court, you're being sued. So, you can have the different defendants be, you're probably named as a defendant, and then they'll probably amend it to include the name of the company and hopefully get you personally out of it. But um, yeah, if you have a domain name that's registered in a personal name, you are officially the registrant, not the company.
The problem is if you now go out and change the who is settings and put your company name there, that's technically a change in ownership. And your priority date may change if you're not living in the Ninth Circuit or under the UDRP rules. So don't run out and start doing that.
Yeah, I think an argument can be made that it's really a successor in interest as opposed to an assignment, right? Um, so, it's different than, and it's similar to just changing your business name, right? It's a successor in interest as opposed to an assignment to a completely new third party. So I think there's arguments against that, or I should say, arguments in favor of keeping the priority date. Um, the fact that, for example, Twitter changed its name from Twitter to X doesn't mean that when it changed its name, it now lost its trademark rights. Uh, well, I guess that's a little different because different trademark. But let's say it was a product. When a company name changes, that doesn't mean that the domain name is automatically assigned to a third party for purposes of liability.
Interesting. The major
Yeah,
publication.
that's true.
Good.
But it's just a trigger that gets them going. We'll see in the K-Suite case that that's one of the issues.
Yeah, and you both make good points. One, you can make the argument, like Jeff said, to say, "Hey, this is an error. It's really I have paperwork to show that this is a company asset." But then, like David says, yeah, you still have to make the argument, and you still have to, spend time now doing that. But I was going to say, with regards to the change of uh, yeah, the who is change. Okay, well, I guess that already said it. I want to think about Twitter and X. You still see major publications when they refer to X, they'll say formerly known as Twitter. What a terrible rebrand this guy did with it. Just leave it Twitter. No one gives a shit. Twitter sounds like a social platform. Even if he wanted to have payments on Twitter, which he does, and you want to call them X payments, do it. But when you have every major publication and news organization still say when they had an article on X, formerly known as Twitter, or they recorded a space on X, formerly known as Twitter. They still do it. I mean, you'll still see it. Okay. Like I said, there was one other piece of news that wasn't on our outline I wanted to touch on, and that was this company, Jeff, and of course you're familiar with them, Fairwinds Partners. Okay, so they're an IP consultancy firm. They had consulted a lot of brands, on the last time that the applications for GTLDs came around. Brands, so their expertise, I guess, is uh, consulting with brands and saying, hey, you want to get your dot Nike, you want to get your brand as your GTLD. Well, they were on, I guess, fairwindspartners.com for their website until now. And this was according to Domain Name Wire. Give them a shout out. That's where I saw these articles. I was looking at Domain Gang, Domain Investing, and DNW just before the show, just to see um, what they were writing about. And these were three sort of legal related articles. But anyway, Fairwinds now is going with home.fairwinds. Or homes.fairwinds. I almost said .com again. It's so awkward, but yet I'm guessing they're doing it because they want, when they start advising and consulting on this next round to brands, you want to fucking put, your money where your mouth is. You want to lead by example. If they're going to recommend companies get their brand as a GTLD, you know, your client might say, why don't you do it? And now they are doing it. What's your take on that, Jeff? And Fairwinds, what do you know? What do you know about them, and why do you think they made this move to go to their, brand extension?
Well, what's funny is that they've had Fairwinds for what, 13 years now? Okay, not that many. I guess it probably got approved 2015, so maybe 10 years, right? Um, they're doing exactly what I had Newstar do in 2011. Um, that Newstar, we announced in 2011 that we were applying for .newstar for our brand. Um, and it was basically, I think you said it, it's to put your money where your mouth is, right? We were trying to get brands to sign up for new TLDs, talking about the value of brand TLDs. And how could you talk about the value of brand TLDs without actually putting your money where your mouth is? Um, I think this one, to me, it's kind of bullshit. Sorry, but because they've had it for 12 years or 10 years, and the only reason they're switching over to is now is it's a complete sales tactic. There's like there's no meat behind that. It's just, yeah, we're going to change now because there's another round coming. Whereas Newstar did it, and then immediately, as soon as it got Newstar, it changed its branding over to Newstar. It didn't, it did exactly what it said it was going to do. But yeah, so if you're going to be talking about the value of new TLDs, you really, and you're trying to get that brands as your clients, then yeah, you should be using your brand, especially if you got it 10 years ago.
We're quickly going to go through the news articles on our outline. If you guys are checking it out, dnlshow.com/outline. So we can get to our four cases today. B1 on our outline was FBI seizes major game piracy domains and international crackdown. It was on Domain Gang. But I just wanted to mention, yeah, so FBI still seizing domain names. In this case, I thought what was interesting was this, it was FBI out of Atlanta was watching these websites that were basically releasing games prior to their actual official release. And not only were they doing that, but they were offering them, let people download these games. Uh, I mean, basically stealing them from the um, owners and just allowing, not necessarily free downloads. I don't know what their business model was, but I do know that there were 3.2 million pirated copies just from February to May in 2025, and they've been doing this for 4 years. So the FBI was watching these sites, and some of the sites, just so you know, were nsw2u.com. NS, or there was a NSWOL or DL.com. In case you guys were going there, now you better, don't go. You'll see the up. Big, BIGNGAME, bigandgame.com. But anyway, you see people still doing it, buying domain names. These happen to all be .coms. We see them on other extensions, I think even more frequently when it comes to phishing and, um, counterfeit type stuff. But anyway, so this were all just a bunch of .com names that the FBI finally, uh, it's really the last thing they do, seize the names. They do the investigation. I don't know. It didn't talk about any arrests, but certainly seems like it's one of the first things they would do. I mean, you can really put them out of business. This is a company that's, pirating games. So before arresting the folks, if you can take down their sites, there's several ways to take down a site that you believe is infringing on your copyrights. So I don't know about it. Anyway, I just bring it up because it was legal. Okay. The next piece of news was interesting. I was going to get you guys. Unless you guys might have read the news and have a comment. David, would you say anything about this FBI case?
Only that I'm still surprised that that the U.S. government is asserting domination over the .com. I thought they gave it up, but apparently not. And I think recently we saw them seize some domain names that were CCTLDs. So that's probably in cooperation with other governments. But yeah, I don't know. It's an alternative remedy for some kinds of companies that have a lot of money and a lot of influence in Washington. But I don't think any of us could use the FBI to seize names.
I wonder if they tried those easier methods to take down the websites, Jeff. Just to.
Well, I think they specifically wanted to leave some of these websites up to get the proof they needed to prove their case. So my guess is that these major game companies whose releases were or whose games were being put on these sites contacted law enforcement and the FBI cyber crime division. Um, they you can go to a registry or a registrar and ask them to take something down, but if it's just infringing or um, even piracy, a lot of registries and registrars won't take action on that because they require a court decision or um, a formal action from law enforcement. And so, yeah, with .com, look, the VeriSign operates .com. It's in the U.S. And so the FBI uh, basically has jurisdiction over any GTLD operator that's based or has offices in the U.S. So it's been doing this for years. Not necessarily with game piracy, but we've seen it with illegal pharmaceuticals and all sorts of other luxury brands. We've seen it with. Um, so yeah, this happens, and it's kind of rare, and it doesn't usually involve a huge number, but sometimes when sometimes law enforcement, in order to build its case, wants these sites to be up for a little bit.
I was doing some uncomfortable pausing there just to have some open air. So if you're not familiar with our show here, Domain Name Law, we usually go through some legal news and then we review UDRP cases. Sometimes we have topics, and next week I wanted to mention, because I see Gary Palmer Jr. in the room, he was talking recently about in the, say, the .eth space, really the Web3 namespace, people getting, whether it's a trademark name, but really specifically individual names. What rights does someone have when you're registering a first and last name from someone? And also a trademark name. What risks do you take when you're doing that in the Web3 realm, in Web3 names? Well, a lot of the same risks that you take here in Web2. So, spoiler. But we're going to be talking about that next week a little bit more. Today we're pretty filled up with our show, but I wanted to say it's an important aspect of registering names in Web3, and what rights do you have as the registrant, and then also what do you need to be aware of, since there's not a UDRP process with some of these platforms with Web3. So you need to be aware that, yeah, you could be on the end of a lawsuit. And then, what does that entail? How would you have to answer? And what penalties could you incur? And basically, what laws you need to be aware of? What laws could you be in breaking? Just is it just simply some Lanham Act, trademark infringement laws? What do you need to be aware of? So we're going to touch on that next week. This week, there was another couple stories that I wanted to get to, and we got to get to our cases. Um, there was a website, NARASMITH.com, Nara Smith. Okay, this was a name registered by this Vanessa Clark, and this was an article. I think I saw it in Domain Gang, but oh, look, it's on the outline. Let me take a look real fast. Give appropriate credit. This was Domain Gang, but interesting article because Nara Smith, there's a model influencer, Nara Aziza Smith, who has like 11 million followers. Well, this person who has like 50 followers, named Vanessa Clark, registered the domain name. Must have, this person didn't try to protect themselves, and registered the name, put up similar products, similar content, and basically just started doing business saying, because this is a famous person and I have followers too. And really, we're not analyzing this case completely like we are our other ones today, but this person just flat out went in there and said, I'm asking 75,999 for the name, dropped the price down to 15K, but ended up losing it altogether in a UDRP. Um, I'm not sure. There was probably some points. The reason why I wanted to bring this up, that
Well,
someone, yeah, go ahead.
I think there's, and this is probably worth further discussion. So David Bernstein was the panelist, and he's going to be on the Levine lecture, which I know is something we've listed as well. Um, and I think the big part of this case, and I'm actually glad Zach's on it, because I think, you know, there's a discussion in here which is not really related to the case necessarily. It's what we call dicta. It's language in there that doesn't really affect the outcome. But there's a whole discussion about whether infringement is enough to whether you can assess trademark infringement in a UDRP action, but also a discussion, and this is the part where I take issue with David Bernstein, which is what is the burden? Is it preponderance of the evidence on balance, or is it's got to be a clear cut case? And it actually cites the UDRP perspectives. And it says that the UDRP perspectives is wrong, or at least in his view, because in the UDRP perspectives, it says that the burden on the complainant is just to show on balance, whereas the perspective says it's got to be a clear cut case. And if it's not clear cut, that's probably a reason why a UDRP panelist should dismiss uh, the case. And Bernstein takes issue with that. I'm not sure why he decided this was the case he was going to try to use for it. But I think this is actually a much bigger case, not because of the outcome, which I think is pretty straightforward, but really for some of this discussion that takes place here. So I do encourage everyone to read it. Zach, you're listening. I would love to discuss this with you all and maybe even write something up on it, um, because I think Bernstein basically says that there's a lot of panelists that will, if it's a trademark infringement case, will dismiss it because that should be in a court as opposed to in a UDRP. And he says UDRP panelists are well equipped to make those determinations. And so therefore he disagrees with those panelists that, will dismiss the case because it should be in court. And I disagree with David on this issue, even though I don't disagree on the result of this case. I think David's view is um, kind of dangerous in a way, and it's an expansion. I think he's basically writing to expand the rights of panelists, and I think that's the real debate. So it doesn't really turn on um, this domain name. Yes, I agree with the result. It's not a controversial result. I think his rationale though needs to be explored.
Maybe we'll
Yeah,
talk
that
about.
was one of the problems with it. He didn't like the disclaimer in the footer because it was too small and not large enough, I guess. But he opened up the door to say that all panelists are as smart as he is and that they should be able to determine trademark infringement when they see it and take the case on. Well, I'm sorry, but he's projecting his skills on all the other panelists out there, and he's well respected in the trademark community. Like when I go to INTA meetings and we have the socials afterwards, everybody looks up to David Bernstein. However, he is not the same. He's flawed as much as anybody else can be, but in other ways. So he's got great skills in certain things, in litigation and brief writing, but here he went off the rails, and his I find his analysis quite weak. Um, this respondent, she registered a domain name a year ago. She said she had cancer. He said, "You didn't give me proof of your cancer." Like, since when do people file medical records to the WIPO UDRP thing? Like, that's privacy protected product, like stuff. You don't do that. And then this thing about, oh, it's trademark infringement. Well, there's another trademark out there for Nara Cosmetics, and that predates all these people. And the only reason why this case was filed is because Nara Aziza Smith suddenly got a contract to promote Cetaphil skin cream because she has eczema. But before that, she was not in the skincare business whatsoever. She was a model that I never heard of because she's a different generation and different world. But Nara is a common growing name in certain countries, especially in Africa and Asia. And this complaint is biracial. I like Nara has a meaning. I think it's an Indian word that means something. It's a positive term. But anyway, yeah, he went off the rails in this decision. We really need to look into it. Like,
Yeah, and again, I think the other thing that I just think he fails to realize is even if the burden is a preponderance of the evidence, right? So that is the burden, right? But that implies or assumes that you're getting all of the evidence. And in UDRP, you're relying solely on the paper. And unlike a court where you have different types of evidence, you have different ways of collecting it, you have cross examination, so that you can really, um, at least the best you can, kind of assess whether the evidence is good evidence for the case. And by good, I don't mean supporting the complainant or supporting a plaintiff or supporting a defendant. It's more like, is it credible evidence? And unfortunately, in the UDRP, there's no way to really judge the credibility of the evidence. You have to either assume it's true, or if it's or that is not true, but it's not based on real credibility that you have in a adversarial process where you can cross-examine witnesses and things like that. So, okay, as long, I mean, if we're using a preponderance of the evidence, I don't think trademark attorneys or anyone else are equipped to make a trademark infringement decision based on the limited evidence that can be presented in a UDRP. So I agree that with the perspectives that if it's a closed case, it should be punted out to a court because you haven't engaged in the type of evidence collecting that a court would, and can't really make a preponderance of the evidence assessment um, based on the limits that a UDRP action has. So I think that's the part that the weakness in David's approach. And I think, yeah, that's this again. I think this case does, um, not because of the domain name itself, but because of what's the way David's trying to expand it and expand the roles of panelists. That's why it needs to be discussed.
That must be why I included it. Yeah, no, thanks, Jeff, and thanks, David. And you guys both are going to have a chance to say it to his face next Monday. If you guys want to, if everybody listening, David Bernstein is going to be the guest speaker, the featured speaker in the Levine second annual, what do we call that thing? Second annual Levine lecture. Okay, so I was close. So he's going to do that next Monday. We may talk more about this case on Tuesday, but I hope both of you guys, I'm sure can, show up. I know, like I said, David Bernstein is going to speak. Zach's going to say a few things. Gerald Levine is going to say a few things, but maybe there'll be a little question and answer session. And yeah, I'd like to hear the lawyers talk amongst each other, and bring up sometimes differences just to get something exciting going on there. But anyway, check out the link. It's B4 on our outline. You can sign up for that's next Monday, 9 a.m. Pacific, noon Eastern. So that's going to be a pretty cool lecture. I got David Bernstein. And I was going to say, so of course, and when you said Dicta, wasn't that the Bears coach? Okay, that's Dicta. Okay, so
Nice.
yeah, the Bears. Okay, so anyway, we'll jump to our cases now. And I think there's a lot of, so we'll revisit that. There's a couple things we'll revisit next week that we touched on today. The first case today is one close to my heart, only because a business partner of mine owned the name and received this UDRP, and we were wondering how it was going to turn out. The domain is KSuite, KSUITE.com. The complainant in this case was Infomaniac out of Switzerland. I'll tell you a little bit about them. The name's real familiar, and I was assuming that they had been part of other cases, and I thought I looked and I couldn't find it, but I was probably spelling it wrong. Infomaniac out of Switzerland is the complainant. GV LLC, spoiler, it's Global Ventures, that's what he makes it sound, is the respondent in this case. Okay, so the complainant, this big Swiss cloud computing company, the largest cloud computing company in Switzerland, which I don't know if that means a lot because I thought Switzerland was pretty small. And they just sort of, So big company there manages 200,000 domain names. So it's sound like, hosting company, hosts everything on the cloud, manages 200,000 names, 150 websites, and 350 radio and TV stations. Sounds pretty cool. But anyway, so this Infomaniac company is pretty big company. They have this product called KSuite, and it's basically a service product that they offer. That it includes email, cloud storage. They offer it to their clients. So you can imagine, say you're a business or a website or even one of these TV stations, and they're like, listen, you want a suite of products? And that's why they call them suite, right? A suite of products, you get all these different products, and of course you pay them a fee. Well, the complainant says they started using the term KSuite in 2020, but their trademark doesn't show that it didn't apply until 2024. But the domain name was registered back in 2004. So the respondent, when he got this complaint, thought, just somebody trying to take my name. It was, I know from personal relationships, he was upset that he got the dispute, the UDRP, and felt like, this is really an abuse of the system because I've owned this name more than 20 years before their trademark. And even if you go back, like the panelist said, who happened to be Warwick Rothney, and I got some issues with his summary. I'm going to go ahead and tell you the complaint was denied. Okay, so the domain owner did get to keep his domain name, but the panelist made some comments that I thought not uncalled for. He can make the comments that he wants, but he certainly left out a key fact, and I'm going to bring it up, that the domain was listed for $3,032 that this company could have bought it for. That was in October 2024. But the complainant, idiots, Yeah, you hear me saying that they made a $3,000 offer. They didn't want to pay the 3,032, so they made a $3,000 offer. The respondent said no, not interested in 3,000. Didn't have any indications of raising the price right then, but I think probably raised the price later. But it just shows the complainant offering 3,000 when the price on the website says 3,032, and I believe it was an Adam Lander, a squad help Lander, and you could have just picked it up. But I bring that up because although the complaint was denied, the panelist basically wasn't thrilled with the respondent's answer, and I'll I'll take a break there, but didn't bring up at all about this Plan B, you know, um, the Plan B action, meaning that you
Yeah,
couldn't. Go ahead, and I'll
yeah. I wanted to
gather
add.
my
This
thoughts.
is so. Before we get into the RD&H issue, um, this is one of the few opinions I've seen that doesn't have a parties contentions section. So he's got a factual background section, all from kind of the complainant's perspective, but there's nothing about what was in the response, right? There's no summary of what the respondent was claiming. Um, it's all about what the complainant essentially alleges. And yeah, there's a couple spots where they say, well, the respondent says this or disagrees with, the complainant. But there's nothing in here, like you said, that talks about the Plan B, that talks about, you know, all of their just the facts according to the respondent. It and that's weird. And maybe there are some panelists that don't summarize the parties' contentions, and I just didn't really notice it in WIPO decisions. But in almost all of WIPO decisions I quickly went to just to kind of see, they always have like a section that says the parties' contentions. And they don't have that here. And that's kind of weird. So I just wanted to point that out before we actually get to the substance
Yeah, yeah,
because
Jeff, and,
I
and
was scratching my head.
I'm glad you pointed that out, and I didn't even bring it up. Maybe the only thing I can think is this was the email that the respondent received from WIPO with the decision. So it's not the published decision yet, which it looks like what a published decision would look like. So I'm not sure. Will it be different when we see it published?
No,
Uh,
no, this is what they email to the parties is what's published. So it's already gone through that publication review. And when did you get it? It should be published by now.
Yesterday, and I don't see it published yet, but I just wanted to bring up what Jeff's saying is usually when we read these decisions, and I wanted to mention, I see Zach is still here. He hates when you call him out, but I do like what he mentioned when we were on a call. I go past the procedural bullshit unless they want to pick a language and all that stuff. I usually don't look at that. I usually go right down to where it says, here's what the complainant is saying, in their complaint. Here's what the respondent, if there's a response, here's what the respondent is, answering the complaint with, or what they're including, and then there's the discussion and findings. Well, like Jeff said, they didn't break it down. They just sort of went to here's the discussion and findings and start talking about the complainant says this, here's who the complainant is, here's what they've said, and then they go into a little bit what the respondent said, but it's all mixed up. It's jarbled. You don't know. Did the complainant say that there was this buy it now price, or was it the respondent? And I know it was the respondent in this case who answered that way, but they're not making it clear at all. You guys can see what we're talking about if you want to click on ksuite.com on our outline. But we're going to get into this a little bit. But David, what did you notice when you first looked at this? Is it the same thing Jeff and I were just talking about?
Well, the complainant did mention the domain directory.com service page and the listing with K-Suite in it. So it was trying to impunge the name as being for sale, and that's somehow bad faith because that was written in the bad faith section. But the decision talks about a domain IQ, and from the documents you sent me, I don't see anything that says domain IQ in it. Did you notice that before? Because if that's the case, they would have been able to use they would have been able to use domain IQ to see that or who actually was the original registrant. And the fact that they didn't bother to look tells me that the lawyer who filed this breached her duty of due diligence and filed a baseless complaint that she should, checked up on first. Was that? Do you remember seeing that domain IQ evidence?
No,
Yeah, and I
I didn't.
think, and what did they say? The complainant said that they didn't want to look into it because it requires a paid service. And I was like, okay, but if you're going to bring it up, then you need to pay for the service. Otherwise, you can't use it. Like, you can't just use results that are just, that don't have the full details. It's kind of weird.
The
It's deceptive. It's very deceptive.
panelist in this case almost it didn't I can't say begrudgingly ruled that the complaint was denied, like I said. So the domain owner gets to keep the domain name, but the panelist didn't bring up that the complainant could have bought the name but didn't want to pay the extra $30. Basically had a chance to buy this name for low four figures and didn't come to an agreement or didn't buy it and then filed a UDRP. That's a plan B. So that's sometimes it doesn't always mean a reverse domain name hijacking, but it's certainly something to consider. The panelist didn't even bring it up in the his discussion about it, but he did bring up that the respondent went after he received the complaint publicly went out there and posted um, this company is trying to take my domain name. I don't appreciate it. I'm pissed about it, and I think they should be held responsible. And for all of you people that work there at this place, keep in mind your executives, and named a couple executives that these are the people that you're working for, trying to take somebody's legitimate assets, who's owned these assets 20 years prior to their trademark. And even Warwick Rothney, the panelist, did say, even if the complainants could prove that they've been using it since 2016, the domain was still registered 17, 18 years before the first use of their mark. So why would they think they would have a shot at this? So that's why the respondent said, I think this is an abuse of the system. I think there should be reverse domain name hijacking. But the panelists brought up this respondent went publicly, which the respondent mentioned in his response that he was, out of frustration that he posted this and sent an email directly to the executive saying, what are you guys doing here? Trying to take my stuff. I'm going to fight you tooth and nail, and whatever I have to do, we'll handle this via the UDRP. If things don't go my way, believe it, it's not going to end there. And was just really upset. Well, the panelists said, well, just because you're frustrated doesn't give you a right to respond directly to the complainant. You're under, I don't know, Jeff, it said some friggin' guidelines here. I'll look at it. But he said uh, I'll look at it. It pissed me off when I saw it because I thought, well, it doesn't even bring up that the plan B, the chance of, okay, here it is. The respondent seeks to justify his conduct arising out of genuine frustration. They're talking about the respondent posting on social media, accusing the complainant of theft and trying to steal the name. So the panelist says that's no excuse. The conduct was clearly inappropriate and in breach of the respondent's obligations under the policy to communicate in relation to the dispute with the center and copy all other parties. So he did respond to the complaint, and he did respond the appropriate way. But in addition to that, he also posted some things publicly. Basically, no one's restricted by this policy to
Yeah,
say,
so technically the rules of the UDRP, Section 8 says uh, that no party or anyone acting on its behalf may have unilateral communication with the panel. All communications between a party and the panel or the provider shall be made to the case administrator. Um, I think it also says that any communications after it needs to be through the formal process and not outside. Although I just think that that's petty from the panelist perspective. That one party's wrong doesn't excuse the other party's wrong. So even if your client or your friend, whatever, was engaged in some activity they shouldn't, that doesn't negate the reverse domain name hijacking, which it seemed like in this panel's mind to kind of do. And then, of course, the privacy issue, I think we should all get into because that's just ridiculous because it was GDPR. Rothney says that we can't find reverse domain name hijacking because the respondent hid behind a privacy service, which is not true on a couple fronts. I think the WHO is actually listed the entity, but yes, the rest of the details were blocked by GDPR, not by a choice, and to use that against the registrant was inappropriate at best.
Yeah, absolutely. It's inappropriate. He doesn't seem to understand the differences and like how these privacy things happen because we're not paying for privacy. We don't want privacy, but GoDaddy is imposing on it because of GDPR, and they've actually gone above and beyond what they're supposed to do. Now, the other problem was the response, and I think when the next case we'll see why, but maybe responses should be more surgical. Instead of throwing the kitchen sink, do exactly, you only need one piece of evidence, and that is the 2004 receipt to GV LLC, that the domain was registered back then by the respondent, and that's it. That's all you needed. You could have sent that copy of that right away to their lawyer. Say, hey, you know what? You have a chance to withdraw this. Here's a copy of my receipt from 2004. I'm the original owner. And if you had done that, and then they still continue to go ahead, that's when you've gotten your RDNH. So
I
the
agree
other
with you
thing
there,
is,
David.
yeah, Ronnie is Australian, and he does not think like Americans. He does not like public defense. He doesn't like naming and shaming. He's Australian, and maybe that's the way they do things there. But we're not in Australia.
Yeah, he didn't like that. One, um, the respondent had said, "I bought this name for this reason," and you're right. If they would have just kept it at, "I registered this name way before," you don't even, but still, always a panelist wants to know your reason. Why did you register it? And this was a domain investor who uses it as part of his numerous platforms. And what was frustrating because the fucking, excuse my language, the panelists couldn't understand. Well, I don't understand. Naming system, then it's going to domain directory, but then he's got contrib here, vnoc. Well, if you know the respondent, these are all companies that work together. These are companies under the same umbrella, the GV umbrella, and each company um, has a task, has a reason for being there. But Warwick Rothney thought, I can't understand this. I mean, I'm going back in the who is, or on the Wayback Machine, and I'm looking at some of these archive pages, and now I see it was going there on one time, here at another time, and basically just didn't understand. It was like, was that, did that really corroborate or uh, you know uh, support the respondent's um, claim of why he registered the name? And you're right, David. It was just a little bit too confusing for the panelist. And then, so the panelist, but he has a right to say, listen, I can't help it. I'm confused. But like Jeff mentioned, it just because he also didn't like that the respondent had publicly reached out, and said some things about the complainant, that it still shouldn't have, you know, completely ruled out RDNH, because there's two main things here, and we're going to get ready to go into the next case. Is this domain was registered 20 years before, and the complainant had a chance to buy it for 3,032, but only offered 3,000, and when it got refused, then wanted to file the UDRP. So those reasons alone, each individual one we've seen in the past, is reason for a panelist to consider RD and H. In this, the panelist almost like just didn't even want to consider it because he didn't like how it all went down. Fortunately, it made, the domain owner kept his domain name, because we've seen terrible things happen. That they'll transfer it because they're just mad. But I was going to say, normally, I would say you want to include a lot of evidence. That's what lawyers do when they're defending. If the respondent would have had an attorney in this case, probably would have organized it differently, but still would have provided a lot of evidence, even though the primary evidence was the pre-date of the domain name, the pre-registration date of the domain name. But can't help it. Sometimes when you're answering things individually, protecting yourself and trying to just represent yourself, you want to throw in, like, one thing that they did mention a little bit, and it is a fact. The respondent owns a bunch of names that have "suite" in it, and he included in his response has thousands of domain names, maybe plus in the five figures, okay, mid five figures of domain names. Long-time domain investor. So there's a lot of evidence to show, no, there was absolutely no targeting. How could I? And then the person could have, I have run legitimate business here, and one of those legitimate businesses is reselling names. But anyway, just frustrating as a long-time domain investor, receiving a UDRP like this, that you think there's several reasons why this is abuse of the system. And, basically you're lucky. I mean, not lucky. I think it's obviously a good decision, but you come out alive. At least you got the complaint denied, because sometimes the panelists just, they want to find reasons why, the complaint is not, in good faith, or the complaint should be considered. Anyway, this one should have been, thrown out quickly. Okay, so that was KSuite, KSUITE.com, which was complaint denied, so the domain owner gets to keep it. This next case, Beach Jet. Hold on for a second here. Let's see. Oh, approve Jeff Neuman. Okay, I'll do it. Approve Jeff Neuman to come up here. Maybe he got kicked out. He's probably got some bad weather over there. Oh yeah, I never did ask Jeff. Jeff, are you back on stage? I don't see him. Well, I'll try to get him back up here in a second. This next one is Beach Jet, BeeBeechjet.com. Textron Aviation is the company that was the complainant in the next two cases. We've covered several of their cases the last few weeks. They file UDRPs like you can't believe. They're going after really a lot of domain owners that have had names for more than a decade, sometimes 2 decades, and have legitimate businesses. It doesn't stop them from filing these complaints. David, why don't you give us a summary of BeechJet.com complaint, and then we'll discuss it.
All right. So Textron used to own a trademark for Beechjet, and they let it expire, but they still own a trademark for Beechcraft. And so that's the trademark they asserted in this case. But the panelist says it's not confusingly similar to Beechjet. And the respondent is actually AP Aviation Services, and they've been a flight training school since 1998. And they actually have provided instructions, flight instructions specifically for the Beechjet 400, the Hawker 400, and another company that actually is remaking these old Beechjet planes under their own brand these days. It's called Nextent. And you know what? I think Textron needs a class action against them. But anyway, is the trademark confusingly similar? No. Is there bad faith? No. They're using it for their business. There's no evidence of targeting. And Brett Lewis out of New York filed this response. He was very surgical about it. He only dealt with the exact issues in this case and basically pulled them apart. And that is the way to do it, I think. That's the best approach, because this decision was clean and it just hit them hard. So I don't think they'll be going after any other Beechjet domain names going forward for now anyway. But yeah, what else did you hit you about this, Todd?
Well, and by the way, Jeff's just having some I don't know, connection issues. I'll try to get him back up here. Um, well, so in this case, the complainant, Textron, said the respondent has no rights in it whatsoever. The respondent is this guy Jason, who owns a company, AP Aviation Services. What really struck me was this guy always promoted his company on his website, the AP Aviation Services. He only used the beach mark, to say we do, service these jets. We're a repair company. Um, or I'm sorry, this was the training company. The repair company is the next one. So basically, the the respondent claims, fair use under the Oki data test, and we'll talk about it quickly. But the respondent used the domains for its services for 12 years prior to this complaint. Now, we bring it up in UDRPs. It doesn't matter how long you've used it for quite 20 years. That doesn't mean that they can't file a complaint against you in court. Sometimes if someone has used the site, it's called a latches defense, where you only have a certain amount of time. Now it's not letting him in the room. Certain amount of time um, to file a case. So in this case, the beach jet case, this domain owner owned it for 12 years prior to this complaint, and they wanted to mention that because they felt like that means something. Well, it really does if the panelist wants it to. And what I mean by that is the panelist found that the respondent provided training services since 1998. In 2017, the complainant even asked the respondent to train some of its customers. So the panelist knew there was a legitimate business there. And the complainant was aware that respondent used beechjet.com. Now, the respondent said, hey, we're using Beach Jet, not Beechcraft, which is what they owned the trademark to. I thought it was real generous of the panelists to say, all right, I'll consider it, not the same. The panelists did consider that including beach in the domain name gave Textron standing to go ahead. It was similar, confusingly similar enough to proceed with the case, but the panelists really sided with the respondent, saying jet is different than craft, and the panelists noted that the complainant lost other recent cases against training schools. And so this was a three-member panel: Adam Taylor, David Safran, and David Sorkin. And they all agreed, that there was no bad faith registration in this because they had registered the name. Well, the respondent acquired the name in 2013. The name was actually registered in 2009, but it really it ended up being a complaint denied. Um, let's the next case really is similar to this and really has more meat on the bone to talk about. But so this Textron company goes after everybody with beach in their name. Jeffrey had a case that was Lycombe, because they also own the Lycombe engine mark. So Textron goes after domains with BEECH in them and Lycombe in them. In this case, they lost. This next case is Atlantic Beach, ATLANTIC BEECH.com. Textron's the complainant, Atlantic Beechcraft Services. So this company uses the full-on Beechcraft in their company name. David, take it from there, and I'm going to try to get Jeff back in here.
Yeah. Okay. So the respondent is Atlantic Beechcraft Services, incorporated in Florida since 2002. And in 2013, they registered the domain name atlanticbeach.com. The respondent has used it for 12 years without objection. And that is, a good point. And they actually have a legitimate website. They repair Beechcraft planes. So the Oki data test is there. They only sell the trademark. Okay, well, they say it should be not bait and switch, but is there bait and switch in this one? Let me take a quick look. I forget. I didn't look at the actual domain name. Oh, it doesn't resolve right now. That's odd. So anyways, Karen said that beach is a commonly known abbreviation of Beechcraft, yes. And adding Atlantic doesn't prevent confusing similarity. Is there legitimate interest? She said it's actually, yeah, that's the whole thing. It's legitimate interest because that's their name of their business. That's what they do. And that's what they're commonly known as. So that's a big thing. That's the first time I've ever seen the commonly known as in a decision and saying, hey, it's good enough. It's in your company name. And yeah, so I think Textron is going to have a bigger problem now going after other brands that they used to use and want to take back somehow and at least hijack all these domain names. Jeff, do you have any comments about the atlanticbeach.com decision?
Or the Beach Jet decision, Jeff. That was the 3-member panel that denied the complaint. Of course, Textron's same complaint in here. Are you there, Jeff?
Yeah, I'm here. I think both of them came out correct. I think Textron has been making a lot of claims, as we've seen. They've just gone on a frenzy in the last few months, and most of them, unless they have are lucky enough to get Dawn Osborne, um, most of them come out in favor of the respondent. Um, and I think Karen's case was a good one to show kind of against the whole David Bernstein um, mentality that that in cases that there's sometimes that you need courts to weigh in, and that they're not decisions, and that it's unfair at a UDRP stage to hold be really strict to the Oki data factors, especially when you have a business that's been in existence for a number of years. So I think Bernstein would disagree with that based on the earlier case, but I think it's the right decision.
Let me make a few comments here. So this Atlantic Beach case, what we're getting at here is, uh, Textron believes they have a right to anything with beach, Beech, or Lycombe in it. Now we're seeing more and more that they're filing so many cases in these last, particularly in 2025. So somebody over there, um, let me look and see who are the lawyers here in this case. Well, it looks like Jeremy Pastrick out of Indiana. Sounds like a Hoosier would do something like this. Now, was he also the lawyer in the Beach Jet? Let's see. Yeah, Jeremy. So he's just really striking out. But the thing is, they have won some of their cases, so it's not like he's really striking out. And some of the ones that he's won were, get a little up in arms about because we're like, this is really a ridiculous decision. But this lawyer for Textron is thinking, listen, we love the UDRP. So what? We don't win. I'm filing them. Who knows? He goes, I'm giving my client a break with prices too. You can't believe it. I love filing these babies. I have it already, the template ready to roll. I see a name. I don't care if somebody's owned it 20 years. I don't care if someone, we'll see. Hopefully they don't get Karen Bernstein as their lawyer, and I'll bring that up because in Karen's case, the AtlanticBeach.com case, um, she answered, of course, for the respondent, but she had the respondent, really hit this head on, saying the respondent, filed a sworn affidavit saying, they're based in Florida. They've been doing business since 2002. They have all the paperwork to show when they first started, doing business as a corporation under that name in Florida, when they registered the domain name. This is all important because when you're trying to show legitimate interest, you want to show that you really go by that name, which they do, that they have a business that they operate under that name, which they do, and they were really important that the complainant was well aware that the respondent, was a company, and a legitimate company, and was aware of the domain name. And they added additional stuff. This is Karen doing a great job, and that is the complaint, all the communication that the complainant had with respondent, and sending to the respondent's email address at Atlantic Beach for the past 12 years. But what was really, I think, interesting in Karen's decision was, because we bring it up a lot, and that is, okay, when you're trying to prove that you have rights or legitimate interest in a domain name, um, the before the respondent receives the dispute, they need, what is really helpful, really what proves your case, is that the respondent has demonstrated before they receive the dispute, because many times you'll receive a dispute and then all of a sudden they start doing all sorts of bullshit, meaning the domain owner says, look, now I'm putting up a site that shows, look, I'm building a theme park, and also I just, filed my LLC, and so on. So before you get notice of the dispute, you want to show that the respondent has already been using the name or is preparing to use the name in a legitimate way, and you know, basically, is offering, as they say, a bona fide offering of goods. Secondly, you want to show that the respondent is commonly known by that name. Seldom, with we know as domain investors, are you known by the domain name. So, usually we have to defend ourselves by saying that we're not known by the name, but we have a legitimate business of selling domain names and so on. In this case, the respondent is actually known by the domain name, and filed paperwork with the state, going by that name, and then the respondent, what was the actual business. But anyway, so Karen really did a great job laying this out, and I think I'll finish by saying, most importantly, the the respondent, um, what she made the point that, okay, so in the UDRP, there's no defense, latches defense, meaning that, there's no time limit. The complainant can always go after it, even if it's 20 years late. But the truth of the matter is, in a court, there is a legitimate latches defense that this respondent would have. And since there really is a defense here, and the respondent has been conducting business for such a long time, it really is not the place of a UDRP panelist to pull the rug out from underneath a um, a domain owner, and basically when he would have a more thorough defense and a chance for discovery and a chance for all sorts of other things in court. So Karen really brought up a lot more, very different than the K Suite decision where the guy just says a bunch of stuff. I mean, Karen really brought a lot to the case. Go ahead.
So I was just going to say that so Textron, this guy on behalf of Textron, has filed 21 cases or there have been 21 decisions in 2025, and they have lost about 24% of those cases. So they've succeeded in 76% of the cases. I don't know. I mean, I would think that with filing UDRPs, most people have, in the high 90% success rate. Um, but, yeah, they just file a lot of cases, and, I guess they could tell their client, look, we won three-quarters of the cases.
And if you think if they spent, say, 50 grand on the filings, and I know it's probably been because some of them were three member that they probably had to pay, but say they spent 50, 60 grand on all those filings, and another 40 or 50 grand to the lawyer, it could be more. So spending 100 grand, and they got, like you said, so they picked up 20 names, put a lot of people on notice. And so really for that amount, it is a large number of actions being taken. Of course, the lawyer could say we file one lawsuit and it would, maybe cost the same. So I think that it shows me that this lawyer for Textron likes the UDRP. And fortunately for domain investors, we like it too, because you prefer to have this than an ACPA action where you have to, actually have a answer the court. You don't want to get a default judgment for 100 grand. So it's just one of those where I don't, we're seeing just as many each week. We keep thinking that they're going to lighten up now that we see that they're, losing, but they're losing more to training. This was a repair shop. So, in this case, yeah, the respondent, repairs these aircrafts when the complainant manufactures, and they made it clear. Okay, so anyway, that was a complaint denied. So 2 cases, Textron loses. We'll get to our last case and get out of here. Suncastglobal.com. And friend of the show, Igor Motsny, brought this case up. And, the more you look at it, the more you realize, well, geez, really terrible decision. Sandra Franklin transferred this domain away from this domain owner. The complainant in this case was Suncast Corporation out of Florida. The domain owner, Polkit, his last name begins with an M, a business person out of India. And how we know it was a business person was you go to the website and suncastglobal.com redirects to suncast.co.in. And if you look at the site, it certainly looks like a legitimate business. They were selling premium brass rod solutions, but basically, products there. And the issue was the respondent did not reply here. So the complainant offers a variety of outdoor products. The disputed domain forwards to, like I said, suncast.co.in, and they call themselves on the website Suncast Global. So you can see why they wanted to pick up suncastglobal.com, which they did just in May 2025. So maybe it was a drop, but so they just picked it up a couple months ago. And this, domain owner has it pointed to their website. The only thing, Igor brought to my attention was, the respondent may have forwarded that domain to their website a bit late or after that the complaint was filed, because the complainant showed that the domain had PPC links, and these PPC links were supposedly selling competing services and stuff. And the panelist here looked at these the evidence, or what was submitted, the screenshots of the website at that time, and probably didn't look at where it's forwarded now, that there's a legitimate company there, and so on, because it's just obvious and it looks like there's no competition. They're basically, the only thing they're doing alike to each other, similar, is they both use the term Suncast, and that just doesn't seem like such a unique name that only one company in the world's going to be using it. So what do you think, David, and then Jeff, and then we'll go our merry
So I
ways.
looked up the Whois records and on security trails, and it shows that this domain has always been at domain control. So let's GoDaddy. There are no MX records. So any email going to postmaster at suncastglobal.com is never going to be delivered to the respondent. And the complaint didn't say that the email went through or that it didn't bounce or anything like that. So they didn't actually take the necessary steps to make ensure that the respondent received notice of the complaint. And that, I think, is a fatal problem with this case. The other thing is obviously that the respondent is in India, US trademarks don't apply. And if GoDaddy's putting up ads intermittently on a website that's forwarded to somebody else, or if the domain owner just didn't set up forwarding properly right away, well, that should never be the fault of the domain owner. That's GoDaddy's internal thing. So I think that this decision is very wrong.
Yeah, I mean, like the problem here, of course, is that the respondent didn't reply. And well, there's a couple problems here. Number one is that the respondent um, didn't reply, and number two is we have a panelist that's very um, what's the word? Very attuned or biased. Some might say biased in favor of trademark owners. Um, and I haven't done the research, but look, if their name truly is Suncast Global PVT uh, Limited or whatever um, it is, and there's legitimate records, the respondent should have replied. But I do also, from looking at the site now, I don't see what Sandra Franklin saw. And so it's hard, right? I mean, this is one you would have loved to see a response, but unfortunately didn't get it.
And
Yeah, go ahead.
the decision mentions they send notice by fax. Well, I went to the website and I don't see a fax number on there. So where are they getting this information? And they said they sent it by mail. Well, you know how long it takes for a mail to come from the United States to India and get processed and delivered? And who knows if it actually got delivered?
I think it's a good point. I think there is a contact us page on the website, Suncast Global One at Gmail. There's phone numbers on there, and you've got to wonder if they tried contacting them. But again, there's no response. You kind of wish there had been a response. It shows the importance, but it also shows that there's some panelists that won't look any deeper into a complaint if there's no response, and it'll accept all that's in the complaint absent a response.
Yeah, there's no obligation for the panelists to review the current website. They might only review the evidence. Igor brought up that the complainant has no Indian trademarks, but you're not going to see the panelist going through all the Indian trademarks if the respondent, hasn't replied. But you would expect, I would expect a panelist, and of course it's up to each panelist. Should they review the current website or only the evidence? I don't think it would hurt to go to. Usually it's, um, I would say usually it's at the detriment of the respondent, because sometimes there's the website, and then it's obvious that they received a complaint and then they've changed the website, or they got wind of a complaint via cease and desist or something, and then they've changed the website, and then the panelist holds it against them saying, yeah, now you changed it after notice of this. But so I think it only makes sense always for a panelist to look at the disputed domain name in its current state. It doesn't, whether you have evidence that shows a different site or whatever. To me, I always just thought, certainly try not to let it, well, it would sway your opinion if you see something that's obvious there, like, um, you know, basically just flat out um, impersonating the complainant is one thing. But I think they would always, I always thought they looked at the disputed domain name. But in many cases, like you're saying, Jeff, if there's lots of evidence that's provided by the complainant and there's no response, the panelist, and I've talked to a few who say, no, I'll look at the evidence. I try not to do much more really looking into it than that, because I don't want to have my research to, tip the scale one way or the other. But in this case, this was, very simple. If you would have looked at the website. Anyway, I guess the point too, forwarding to suncast.co.in, well, that tells you already. So if this panelist was ruling, and I know the Indian domain names have their own process and their own, service providers, how they handle the complaints. Um, would she have transferred suncast.co.in because of a no reply? Because it really makes it clear that Suncast is obviously a name that's used, you know, uh, more widely than just by this company in Florida. So I think the point of this case was, yes, Suncast is used by many companies. So any of those companies who intends to do business on a global scale would seem to have rights to Suncast Global. But yeah, this was one. I just want to add one transfer in here that is, once again, even, and we talked about in the first case, K-Sweet maybe could have sharpened up his answer, but the important thing is still answering. Why did you get it? The panelists might not always be thrilled with all the evidence and your entire answer, but you can always say, one thing you can always say is, if it's in fact true, is under penalty of perjury, I submit the sworn affidavit anyway to say I did not know of them at the time, or they don't have I did not know of them. They do not have a Indian trademark, and when I registered this name, of course, it didn't target them because I wasn't aware of them. That's if you really weren't aware of them. And I'm thinking in this case, this guy might have said, I was not aware specifically of them. I was aware that Suncast is used by numerous folks. But anyway, yeah, I definitely disagree with this decision. Okay, so before next Tuesday, we have several things I wanted to share with you. So tomorrow, 10 a.m. Pacific, 1 p.m. Eastern, you're going to catch me and Chad Fokening in a Spaces here on X with Fred Sue of D3. I hope you can join us. If you want to know the link, go to my profile and you can see right in my timeline I have the link for that space. That's tomorrow, Thursday, 10 a.m. Pacific, 1 p.m. Eastern, DNX show. Me and Josh Reason talk about domain investing and a lot of great topics to talk about. And if you should check out Josh's profile here on X, it's at Josh dot spelled out DOTCO at josh.co. We're going to talk about a lot of the things that he's been posting about this last week on his timeline. So if you want to look at some of the topics before I get the outline ready, which is going to be at dnxshow.com. Like this one's DNL show. So we got a couple so that's Thursday. And then next Monday, there's a, before the next Tuesday domain name law show, there is that Jerry Levine annual lecture with David Bernstein that you can sign up for free. So you can go to our outline, dnlshow.com/outline. You'll see B4 and you can sign up for that Monday lecture. It's going to be pretty cool. A bunch of lawyers in there talking with panelists. And I think they're even going to have a little question and answer session, but should be interesting. And we're going to touch on that Tuesday. So thank you so much for everybody being around. We appreciate you sticking around and listening to, these domain name law topics. Have a great afternoon wherever you're at. Great rest of your evening. See you next time.